We're live.
All right, we're back in Senate Judiciary, February 27th. With S-193, we have a new version that incorporates some of the changes that we discussed yesterday. It's pretty close to a final version. We want to fix it though. And we have Eric from the council here to walk us through that.
Thank you and good morning again, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through a revised amendment to S-193, which is an act relating to establishing a forensic facility for certain criminal justice involved persons. This is version 4.1. Just double check, is that the version everyone has at the moment? Excellent, good. So, based on some of the testimony yesterday and the committee discussion, there are some additional changes highlighted to version 4.1, which are highlighted in yellow. Sorry.
I have 3.
You should have 4.1.
It should be on your desk.
Keep looking.
Jeff, can you have a pen over there by any chance? I think you forgot my pen.
There you
Oh, thanks. Sorry about that.
go. Is it, or are those Bob's? Here's an extra copy.
Oh, great. Thanks so much.
Okay, so although no changes on page 1, just a quick review, because the first section we're talking about now is the competency restoration section. So remember that a person can get to the forensic facility either because of having been found incompetent to stand trial or not guilty by reason of insanity. This first section has to deal with the universe of people who are found incompetent. So there's 4 criteria that would lead to a person being committed to the forensic facility, and that is on page 1. These are unchanged, but just to refresh your recollection, because it leads into the subsequent part of the bill that we'll talk about. Persons charged with an offense punishable by a life sentence, and either, this is subdivision 2, they're either held without bail, or if they're not held without bail, then their release would create a substantial risk of bodily injury to another person. So again, it's in terms of the universe of people going to the forensic facility, it's not necessarily everybody who's found incompetent, because if you're found incompetent and you're not held without bail, then you don't go unless there's a finding that you're a substantial risk. So additionally, at subdivision 3, the person's not currently receiving treatment under a hospitalization order, either in the civil commitment process or the criminal commitment process. So this is only for folks who aren't already getting treatment. And subdivision 4, I just mentioned, they've been found not competent to stand trial. Okay, so look again at the bottom of page 1 over on page 2, just to help us understand how this process works. Upon admission, so somebody qualifies under one of these criteria, they go to the forensic facility, the person is evaluated for competency to stand trial not less than the short order of either, now over on page 2, every 6 months, or if the forensic facility's clinical services director finds that the person is likely competent to stand trial. All right, so think about that for a second. So that somebody's in the facility, right, if they go there, then they're going to get reevaluated either every 6 months, or it could be sooner than that if the clinical services director notices, because remember, this person's getting ongoing services, ongoing competency restoration services. If the director says, I think this person's restored, then they get a hearing for that, an evaluation, sorry, based on that as well. So either way, they would get reevaluated either every 6 months, or if it looks like they have regained competency. Okay, so you've got that status, or that procedure as to what happens. So then we're transitioning to an issue that you see where the highlighting is on page 2. And this is the issue of the universe of people who cannot be restored, right? What happens in that? Remember, the committee had a lot of discussion about this yesterday. What about somebody, and you'll see, line 6, at the request of a party, the court may order that a second or subsequent evaluation, remember, every 6 months, right? At the least, they're going to get evaluated every 6 months. So every 6 months, this evaluation could include an opinion on whether the person's competency can be restored. That's still highlighted language, line 7. So what could happen then if there's this evaluation based on competency restoration? If the court finds that the person may be found likely competent to stand trial, then the court notifies the state's attorney. That makes sense, right? They find, oh, actually the person may be competent, so they'll let the state's attorney know. But now we start in the highlighted language. If the court finds by clear and convincing evidence that the person cannot be restored to competency, The court shall order continued treatment of the person, taking into account the least restrictive conditions applicable, unless subdivision B applies. Now, this is remember the process the committee was talking about, which is, well, if someone has been found not restorable to competency, and they're not a danger to anybody, shouldn't that person be released? I think that's where the committee was going. So that's the process that's set up in subdivision B. So two things could happen if they find that the person's competency can't be restored. The one I just mentioned, they could order continued commitment, that's line 12, taking into account the least restrictive conditions, unless subdivision B applies. And what is subdivision B? Turned out, if the court finds that the release of the person who cannot be restored to competency would not create a substantial risk of bodily injury to another person, in that case, the court shall order the release of the person, pursuant to these conditions of release. Now, this language didn't just come from nowhere. Remember, the committee may recall this. This is all, that same process is in the not guilty by reason of insanity section. So I just cribbed some of that language and paralleled it here. So it provides for a release of the person if that wouldn't create a substantial risk of bodily harm to somebody else, and they would be under this possibly prescribed regimen of medical, psychiatric, psychological care and treatment that's been determined appropriate by the Forensic Facilities Clinical Services Director. And they have to comply with that. That's over on page 3. They're supposed to comply with these conditions while they're out. And then just going to skip ahead a second. Just go to the bottom of page 3. And this, because this actually works well with this other concept we were talking about yesterday, which is what about the commissioner's authority? I think Karen talked about it as well, to immediately bring someone back in under certain circumstances. So the idea, and again, this is parallels the NGRI situation. Look at the bottom of page 3. The commissioner shall, and here's the highlighted language, shall actively monitor compliance with orders issued pursuant to 2B1. And that's the one we just talked about. That's the order to go out into the, you can be released into the community, you have these conditions, the commissioner monitors compliance, and then they can order return to the facility. That's over on page 4. If the person then has created substantial risk of bodily injury.
What does actively monitor mean? Does that have some sort of legal, does that mean they check in with them once a week? Does that mean that they're watching them on a camera? What does that mean?
Yep. It doesn't have any other than plain language meaning. It doesn't have any particular, like a legal term of art. It isn't that. That's just the language that was used in the original DMH proposal about the NGRI population. So it's not any more specific than that. Or at least not any more defined. But so that's the idea of the process. So you've got a situation where the person could be released if they're not going to be a harm to somebody else. If they've been found to have a circumstance where the competency could not be restored. But you also have a process for bringing them back into the facility if it turns out they are dangerous to somebody. That's the idea of those two highlighted pieces on pages 2 through 4. Should we move on from that section? Or?
Quick question, I don't know if it's going to be a quick question, but page 4, line 3 and 4, the commissioner has reason to believe that the person is again incompetent. Any thoughts on how the commissioner would make that determination?
I would think that it's really just because this commissioner supposedly, as Senator House case, pointing us to engaging in active monitoring of compliance with the orders. So I don't have any specifics about how that would happen, but I think presumably they're actively monitoring. That would mean that hopefully there would be some information loop, so they would be, and they're supposed to have as part of their release plan, explicit condition of release, comply with prescribed regimen of medical, psychiatric, psychological care or treatment, together with any other conditions appropriate to protect the public. So hopefully that creates a feedback loop where they find out.
I can certainly understand the commissioner's ability to monitor whether compliance, but I wonder what expertise the commissioner of corrections has in incompetence. Because he may they may be actively monitoring, and sure, they know, like, oh, are you taking your meds, are you not taking your meds, are you, but incompetence, I mean, that's determined by a clinician and a court, so what expertise does the Commissioner of Corrections have to determine if the person's incompetent or not?
I'm wondering if it makes more sense to have the clinical services director provide that feedback to the commissioner. Or rather, the clinical services director being the one who determines or has reason to believe that the person isn't complying and incompetent again. And then the commissioner would be the one who has the authority to issue that order to bring the person back, but with the consultation of the clinical services director, who presumably does have the expertise to make such a determination.
So maybe something like page 4, line 3, if the commissioner, either in consultation with the clinical services director or on the basis of information provided by, something like that?
Isn't that already implied though when you say a commissioner or a secretary has the power to do this? We assume that they're acting on the advice of all of their subordinates who are on a daily. So
That's how the DMV commissioner works with suspensions and all that.
yeah. So I don't read it that the commissioner, him or herself, has to be actively monitoring and then coming forward and saying, I believe this, but that the commissioner's people, one of them being the clinical services director, might, then ask the commissioner to use their authority to do this.
Yeah.
If that makes sense.
And then we have Karen Barber on the Zoom. Karen, I don't know if you have any thoughts on this, if you wanted to chime in this conversation.
Sure. For the record, Karen Barber, General Counsel, Department of Mental Health. Yes, Senator Bruce is absolutely correct. When it says commissioner, it's the commissioner's people. So it's whoever is working under the commissioner that's working on those things. So in this case, I'm sure it would be clinical folks that are doing it, but ultimately, because the commissioner is responsible for the department, they would be the one, whose name is on it. But of course, staff are heavily involved in everything, including clinical staff.
Makes sense. Fine with that. Thank you. We're good to keep going with the walkthrough. Unless
Okay.
there's other questions on this area.
The next couple of changes are on page 4. See, the first one, line 7, is just some language cleanup that Senator Norris had pointed out the last time. There's some language appearing twice. Lines 9 and 10, I should have actually highlighted the state's attorney phrase on line 9, because you remember this is the issue of the burden shifting. Who has the burden, and what is the burden going to be? And in this situation, although no, I'm sorry. Actually, in this case, it was the state's attorney all along, so that was not a change. So it's good that wasn't highlighted. But in this case, you may recall the committee's decision generally was that the way you wanted to move forward with the issue of who is going to have the burden of demonstrating that the person should be in the facility or should be brought back to the facility, depending on the circumstance, was going to be with the state, and the state would bear the burden by clear and convincing evidence. So you'll see in several different locations that change being made, and this is one of them. So in this case, it's specifically to do with the readmission. In other words, it's somebody who has been found competent, released to the community, and then the commissioner and the people in the commissioner's department, if they have reason to believe the person is incompetent, then the immediate readmission to the facility, if the person's continued release would create a substantial risk of bodily injury. In that situation, the state's attorney has the burden by clear and convincing evidence to prove that the person is not competent. So to get them back into the facility, the SA has to show by clear and convincing evidence that they're not competent anymore. So that's the change there. And we'll see more of that later on in the not guilty by reason of insanity context. Over on to page 5, this is the issue of, remember, this is section 2 now. This is the dismissal of some cases in which a person has been found incompetent to stand trial, but the case has been inactive for a period of time. And in that case, the new language requires dismissal. The question had been, should that dismissal be with or without prejudice? So I think the committee went in the direction of without prejudice. That's the change there. So then, now we're on to page 7, and this is the hearing. So this is the initial hearing for a forensic facility admission for somebody who's been found not guilty by reason of insanity. So in that situation, looking at page 7 again, remember the court has to have this hearing within 40 days after the person is sent to the facility after being found NGRI. The court has a hearing, and under the previous version, it was the person's burden, the person who's been sent to the facility, to establish by clear and convincing evidence that they are no longer suffering from a qualifying condition that would create a substantial risk of bodily injury to somebody else. So the committee went in the direction of deciding that burden should be the same, clear and convincing evidence, but it should be on the state since the person is being committed. So you see where you see person on line 2, that's changed to state's attorney. Grammatically, you had to sort of restructure the sentence a little bit because the state's attorney wouldn't be showing that the person is no longer suffering. They would have to show that the person is suffering. So, and that's the same change in line 6 and 7, just referring to the finding that the court has to make. Again, lines 13 and 14, same thing, person isn't released until the court finds by clear and convincing evidence that they're no longer in this qualifying condition situation. Again, no changes to the process that allows the person to file a petition. Again, it's sort of similar to the incompetency situation where the person can, in this case, it's every year, can file a petition every year. That's line 13, page 9. Once per year, the person can file a petition to have their not guilty by reason of insanity or their status with a qualifying condition, danger to another person, reevaluated. But it could be sooner than that if the clinical services director decides that, based on the treatment, that the person has actually changed their status, so they can file sooner than a year.
I thought that if the individual's attorney comes across new information or wants to petition the court, are they able to, or does it have to come just from the clinical services director?
Well, you mean on the annual, the once a year thing?
Yes.
Yeah, definitely the attorney, for sure.
Okay.
Yeah, when it says the person, it's kind of like the commissioner reference earlier, that it's assuming that it's going to be counsel on behalf of the person.
Okay, yeah, I just wanted to make sure that it's not a situation where somebody who's not guilty by reasons of insanity, who is committed, that it's not up to that individual, or I'm sorry, it's not up to the clinical services director to say, yeah, you can petition the court if you want to. But
Right.
rather, the attorney for that individual can petition.
Right.
the court. Okay.
Yeah, it is, and it's both, not either or.
Okay.
So, yeah. Right, so that's that process. The qualifying condition over on page 10, forensic facility qualifying condition definitions remain the same in this draft. And I guess that was it. I thought maybe there was one more change, but there was not. All right, we ended up leaving the language. The discussion had been about the page 12, lines 5 to 7, the Commission of Corrections consultation with the Commissioner of Mental Health, and I think the committee ultimately Just decide to leave that language as is. And, yeah, that's it, Ms. Stratford.
DMH has some thoughts.
Yes,
Right.
so on page 7, I think there's a remaining unless, and if I'm correct, I think it's saying that they would go to the facility if they don't have a condition.
What line are you on, sorry?
It's page 7, lines 1, 2, out of that little section.
Oh, yes, thank you, nice catch. Unless should be if, I think, if I'm reading it right. If.
Oh, yes.
Right.
So,
Right.
That's-
Yes, nice one. Literally the exact opposite of what was.
It's probably because we had to switch the language, because
Yeah.
before we had them proving the state's
Yes.
attorney, so
Yeah.
yes,
Right, right. Definitely,
important catch,
for sure.
and I
Thank
see
you.
how it happened.
Right. I hope it didn't happen. Thank you. Yeah. Just double checking other uses of like the word until on line 13, but in that case, until is correct. Yep. That's the one.
Committee, any further questions or comments on things that we need to change on this bill at the moment?
I think it's looking pretty good.
So, set,
I mean, I continue to think that it is unconstitutional to keep these people in jail, but that's not new.
why do you think it's unconstitutional?
I mean, these are people who have been, particularly the group of people who have been convicted of a crime. I don't think we can put those people in jail.
Okay. I think that we can, and it is constitutional. The majority of other states have similar language, not just for felonies, but across the board.
But they do not house them in a correctional facility, under the custody of the Department Commissioner of Corrections. Yes, there are forensic facilities. They are not housed in jails.
Of the approximately 40 of them, there are about 6 that don't have jail. And there are about 6 where it's unclear. But the others either have forensic facilities attached to their jails or within their jails, or forensic facilities that are essentially correctional facilities. Any other comments, questions?
Wondering about the process the chair would like to pursue. Would you entertain a motion?
Not quite yet. I do want to hear from potentially WellPath and the state's attorneys, specifically regarding the language for whether or not, for the hold without bail language. And just to make sure that doesn't have any unintended consequences. I want to make sure that it's a bill that's narrowly tailored to life offenses and for people who are generally held without bail in those circumstances. And so, I know health and welfare and institutions want to do a flyby, or whatever we're calling it now, of this bill. Actually, before I forget, Daphne, do you mind emailing draft 4.1 to both committee chairs and their assistants? Thank you. This morning in health and welfare, I mentioned, they have it on their agenda for Tuesday, and they also have contact information for WellPath, because they interact with them more often. So they'll be hearing, hopefully, from them, and institutions will take a look at it as well. their jurisdictions, they see some glaring issue that needs to be addressed, or if they have any recommendations, then we can address that. So my hope is to vote it out either Wednesday or Thursday when we get back, so still be before crossover. And that's, yeah, so that's the timeline of it.
Great, thank you.
All right. Anything else from DMH while you guys are here?
No, I don't have anything. I just wanted to be available in case there were any outstanding questions. I appreciate all the work the committee has done on this and look forward to the continued conversation.
Excellent, thank you. All right, well, thank you, Eric, for all your hard work on this as well.
Yeah, definitely. It's an interesting bill.
All right, so we are done, and our agenda will, Sarah Norris?
What happened to 186?
186, I need to do some more follow-up on, with some other witnesses to see what that bill can or can't do, whether, I mean, it's a very small bill, so, you know, if, after I have some conversations, perhaps we can vote it out on Tuesday or Wednesday, the week that we return. And then going to see what we're gonna be able to do with that DUI bill. I think it's 179.
Yeah, I think it is 179.
Well, no, that's just language. Well, either way. So that'll be the week when we get back, and then we'll start diving into the House bills. Yeah, the ones I just described are really the feasible ones that we can pass before crossover, and we can otherwise start digging into what the House has sent us. Anything else before we adjourn for town meeting?
Thanks to Eric.
Are we changing the language in the recovery resident? I thought you were going to have an amendment.
Yep, got language for that, so I'll be presenting that.
Oh, okay.
Yeah.
Oh,
I wasn't sure, because it was judiciary-ish if the committee would look at that, but I don't need to. Figure out what I'll do on the floor.
Does it use the word crime, commit a crime?
It's charged with a criminal offense is what it gets amended to. They think they voted it all out favorably this morning.
before it was committed a crime or theft, right?
Yeah, the original language was commits a crime, and you technically haven't committed a crime until you're convicted. And so that's typically 2 years down the road after you get charged with a crime. So just bringing it in line with how we have it written everywhere else.
And theft is a crime, so it kind of doubled, right?
Yeah, well,
Did you
the
lose that?
theft part is left in there.
Really?
The reason being that, at least according to the residency places, they wanted that differentiated so that if there is a theft, it's not that they have to call the police and they can just handle it internally,
Oh.
rather than getting police involved.